conversation, but I wanted to put a framing to our conversation. There are many issues that I would imagine all of us could identify as being problems. Okay? And I think that that's important, and some things that I might think are not a problem, you will have identified are, and that's good. But actually, if we're going to be building towards a better future, we've got to put that in the framework of problem solution. Okay, so in that context, when we get asked the issue about why is justice relevant, I'm going to put it in that context, and all of the other questions that are asked here, just to give us a basis for the conversation. Okay, so the idea that justice is important is because let's look at the scenarios that exist in different parts of the world for all sorts of reasons where justice as a system does not prevail. What you have then is a legalization of the exclusion of a whole bunch of people. That's the first thing. So you can have a situation where there is no system of justice that gives an equality to women. There is no system of justice that even acknowledges the existence of communities. If you take, for example, the Rohingya in Burma, there's no justice. They are regarded as a group of people who actually are stateless and who don't exist. So statelessness already begins to tell us that when you are in a situation of statelessness, your possibility to engage, to be part of something, to be included is very, very limited. And therefore justice is not part of your domain. If you have a situation where there is no justice, you don't have a basis to include people in a way that is building. You don't have a basis to include people in a way that can develop a future where there's stability, possibility for everybody as individuals, as communities to grow. So there is an importance of justice, but what is it? What is justice? Is it just the courts? Is it the laws? Somewhere we have to find a common understanding of what justice is, because you might say, well, okay, I go to the magistrate's court, or I know my friend went to the magistrate's court because she has a child and there is nobody, the father of the child is not paying maintenance. She went to court and she's been back to that court 12 times and no result. Even worse, somebody who may know a young man who was assaulted, right? He's been back to court, also 12 times. You know, is the court justice? No, not on its own. Second thing is that you've got people who will go to court and receive a response from court, which even if, you know, the court appears to be at least on their side, somehow doesn't give a solution. So, for example, you have schools who will go to court to say, we don't have enough funds to get the chalk for the boards. We don't have enough funds to get the writing materials and all the learners. In fact, we don't even have enough funds to employ the teachers who are supposed to be employed in this school. And the court will order this is wrong, okay, and the court will say it must be fixed. And 3 months later, it's not fixed, right? So, is an order of court justice? Okay. Thirdly, there may be some laws that we can see why they're there, but we are unhappy about certain aspects of those laws. So, for example, you'll know that historically a law was passed in the democratic South Africa which said that because customary marriages historically haven't been properly embraced and recognized by law. The solution in that law was to say all customary marriages that have been concluded up to date have a particular status, and then all customary marriages from the date of that law going forward will automatically be in community of property. And obviously many women who are very committed to engaging in customary processes and customary practices were saying, actually no, we need the choice, whether it's a customary marriage or a statutory marriage. So there was a need for that to be addressed in a court and changed. So the law, the courts, the decisions of the courts on their own are not justice. Okay? Justice is a higher bar than the law. So when we think about the law and we think about the institutions of the law, when we think about the state that creates and administers the law, we then have to say, how do we use this essential set of tools to attain justice? It won't happen of its own accord. It needs people behind it, people underneath it, people around it, because on its own, it's not going to deliver what we want. Okay, so I think that's the very important thing, first of all, to say when we're looking at what is justice. It is something that is definitely enabled by the framework of the law and the framework of the state. Definitely. So if you're stateless, if you don't have law, if you don't have courts, there's no possibility. But even if you have those things, you still need to use those things to develop the justice that you want. Why is it relevant in South Africa today? Because if we don't have a set of laws that are delivering justice, we don't have a trust of people in that framework. And if we don't have a trust of people in that framework, eventually the framework crumbles. You've seen that in Somalia. You've seen that in Eastern Europe, when Czechoslovakia dissolved, and then we've got, all of the problems still that are in the divided Bosnia, Serbia, and so on. So you see it now, tragically, in Syria, right? So if you don't have the law, then you don't have confidence in the law, you don't have trust in the law, it begins to fragment. People take the law into their own hands. Okay? Now, that's the relevance. Now, if we look at present day South Africa, is it relevant? Sure. I mean, I was driving here and listening to very concerning situations in KwaZulu-Natal, where we've got a situation where people who are in political parties, sometimes in the same political parties, sometimes in different political parties, are actually reaching a point of friction that has seen violence and has seen death. We can't go back to that, right? So yes, it's absolutely relevant that we ensure that the law is delivering and that people are actually within the framework of that law seeing opportunities to have difference, to make progress, and even if they are not going to be the person who is the counsellor, that should not be what gives us our only chance for income and our only chance for a career. That can't be how things work. So we've got to change that. Okay. So when we see law as an instrument for justice, it is very much how we use the law, and there are various ways that we can use the law. First of all, before we even get thinking about the law, we have to think about what we want the law to address. So, if you take, for example, if you take the issue about, I'm going to talk quite a lot about local government because that's the year we're in and that's quite relevant. So if we take the law, for example, that deals with local government elections, you know that unlike national and provincial government, in a local government context, you've got a very interesting set of realities. You've got people who are elected as a result of proportional representation, and you've got people who are elected as a result of having their own credibility affirmed within their ward. Okay? So that gives us a taste of two different electoral systems. That is quite an extraordinary kind of opportunity for us to think about. So when we're looking at that law, the question is whether or not the kind of idea of direct accountability of the ward councillor versus a slightly indirect accountability or very indirect accountability, depending on how you think about it, of the person who is the proportional representation person. When we're thinking about that difference, are we sure that we have got a law or a framework of legislation for local government that really gives us the possibility to test it? So, let's say we've got, in our area, we've got our ward councillor, and then we've got our proportional representation councillor, who might actually, by the way, live in our street, for example. So both of them are very concerned about what happens in our neighbourhood. Now, what power do they have? Is there a difference in their power in terms of the process of planning, the street lights, the paving of the roads, the collection of the refuse, the collection, the delivery of water, electricity, and so on? Is there a difference between them? What is the difference? Okay. Second question, when they initiate planning processes, who initiates that planning process? And how do they do that? I could go on with many of these things, but the important thing that I'm getting to here is to understand this law. So, at this point, that level of distinction is not clear everywhere in all of the law. It's clearer in the case of metros, because we only have wards and the metro, but it's very difficult for people who live in non-metro areas. And if you want to change this country and make it a better place, you can't see your whole existence in terms of metros, because millions of South Africans will not be able to use our country as a whole enough if we don't deal with people who live outside of the metropolitan areas, who live in rural communities, who live in small towns and so on, where they have got wards and municipalities, they've got districts, and only then have they got the issue of provincial government. So we need to understand how it works for people in both of those areas. The point now that I'm saying is, when we're looking at the law as an instrument for justice and we're thinking about local government and we think, is this good? Is it good to have ward councillors? Is it good to have councillors who are elected in terms of proportional representation? Does our law give us the tools to compare? Because if I ask you which is better, will you be able to tell me why? From actual concrete information. This is what we need to be able to engage, because then it means if we've decided, for example, proportional is better, okay, I know that the current trend of many people is to say, national government is the challenges of accountability, provincial government is the challenges of accountability, maybe everything should be wards, okay? Some people are saying wards, actually our ward councillor, we never see this man. We never see that woman, so what the hell is the difference? Okay, whichever way it is. The point is that for us to be able to think about which works more robustly, or maybe a combination should happen at all levels. Maybe we need a directly elected premier, for example, right? We've got to know that the current law enables us to assess properly so that we know what we're getting into. And that goes with all law. So, we've got, for example, a Land Restitution Amendment Act. And why was the Land Restitution Act amended? You know, in our Constitution, it says that because we are using our Constitution not only to embrace a new future, but to overcome the legacy of the past, the disenfranchised situation of people is not solved purely by the vote, when people were forcibly removed from their land and all of that historic disadvantage, but also all of that actual dislocation of people from their land and their communities took place. There has to be restitution for that. So we have the land reform bills, and one of them is the Land Restitution Act. So today, we don't only have a Land Restitution Act, which was passed in 1990 or promulgated in 1998. We have a Land Restitution Amendment Act. Okay? Now, when we talk about the importance of understanding law, we need to understand, well, is this amendment an improvement? The amendment was supposed to give the opportunity to certain communities who had, for various reasons, in the 1998 period, been excluded from making claims to land that they had been forcibly removed from. And in particular, the Khoisan community, who are an indigenous people that had been overlooked in a variety of ways, they had not been able to claim their land because the law spoke about land claims very much in terms of a date, a ceiling date, a benchmark date, firstly, and secondly, as a traditional community, a customary community, partly because I think of a real lack of awareness of structure within that community. There was not an outreach that was sufficiently strong to that community to explain to that community about the land claims process. So the new Restitution Act is supposed to remedy that. Now when you're looking at is that what it does? You've got to be able to figure out whether there are any intended or unintended consequences from this legislation. And of course, one of the one of the consequences that is not just opening to new people is the fact that of the land restitution claims that have been lodged, some of them for 18 years, right, nearly 20 years, they haven't been resolved. People have been living in limbo. Now what happens when the very same land that they've claimed is now going to be claimed by somebody else? Also, you've got a whole lot of claims, thousands, involving millions of people, hundreds of thousands of communities, right, which add up. You've got a whole lot of claims that are unresolved, and then you've got a whole lot of new claims. Which is going to come first? Are you still going to have them in a queue? So, tomorrow, there will be a court case brought by 3 individual communities. One is a community that actually got its land a portion, assigned to it, but has not got the title. One is a community that has been successful in its land claim, based in the Pafuri area of the Kruger Park, doing fantastic things with sand parks and so on. But because of the way in which the traditional leadership structure is concerned, it is anticipating that the traditional leadership of another community are going to try and claim a bigger territory, including the Pafuri area. The third community are farm dwellers who were evicted from farms, and none of whose claims, by the way, have been processed. And then you've got 3 civil society organizations, Lamosa, Afra, and Nkuzi, who are joining those 3 communities and going to court to say, this act cannot be, right? Now, that's the kind of way in which we have to use the law, because in doing that, what are these 3 communities putting forward? They're not only, by the way, putting forward the fact that there have been problems in the past. They're not only putting forward the fact that there are problems with this legislation, but what they're putting forward is there has to be a solution. So it's got to be a solution to the legislation and a solution to the fact that more support is needed for land communities that get resettled. You can't put a community on a piece of land and then say, cheers, bye, right? I mean, what do we think that all of the apartheid systems did for white farmers in this country? Do you think big commercial white farms happened like that? No, they happened because of a lot of state support. That's what this particular case is going to highlight. That's using the law. How do we create a just South African society? We create that society by really getting people to understand that, as I said at the beginning, the law is our instrument. We've got to sharpen it. We've got to make sure that it's appropriate for what we're wanting to do. We've got to design it sometimes. We've got to really get to imagine what some of the intended and unintended consequences are. But law is law. Activism, politics, and community organization are not law. And law can't survive without those things. That is where people in all walks of life, whether you happen to decide that you want to go into setting up some small business within a community, whether you decide that you want to be involved in some kind of professional organization that represents people, or trade union organization that represents workers, or a cultural or a religious organization, or you decide you want to actually go into the whole sort of formal political structure as an elected representative, whichever of those options or any other option, there are certain skills that you need to appreciate have to be in our society to make it work. The first skill is to be able to listen, particularly to people who we feel are part of the solution and experiencing the most of the problem. So it's no good for us to go into an area, to be part of a community, even part of our own families, and see what is wrong, but think that we know it all without asking the questions. If you don't ask those questions and you don't listen to those answers, you can be 100% sure that whatever you put forward as a solution will not work. Partly it won't work because it won't be properly nuanced and properly structured. But the most important reason why it won't work is because you'll be on your own. If you begin to bring people closer to thinking the way you think, even if you are the person who's going to lead and craft that, you've already got the people and the mobility and the mobilization behind you to actually ensure that whatever the solution is driven. That's the driving that you've got to do. So I would say that that's, for me, how we create a just society. We look at the people who we think are part and parcel of the solutions, and especially those people who, at the moment, for a range of reasons, historic but also current, we've got a lot of inequality that has actually gone a lot bigger in our current situation. We look at those people who have been excluded. All people have got huge opportunities, huge potential, we've got to harness that energy if we're going to build a new society. And we listen to those people, particularly the ones that are most excluded, and work with them to formulate the solution. Whether that formulation of the solution is in terms of community organization, food gardens, some company or whatever, or whether it's a solution of how do we use the law. Even though the Legal Resources Centre is an organization of lawyers, if those lawyers do not spend most of their time before getting to court in conversation with the communities, the cases will not see the light of day. The cases will not have the back end. The cases will not be enriched. Absolutely fundamental in all of our work. And then a few reflections on the constitutional writing process. And the constitution making process was a privilege that I was directly involved in, it's difficult for me to describe the kind of stimulation, excitement, commitment that went into that process. It was a process that was deeply consultative. I'm sure not every single person in this country was asked for his or her opinion, but I can tell you there was a huge outreach, and there was not a single piece of correspondence that was not properly read and processed. So, for example, one of the chapters that I was very closely involved in the drafting of was the chapter on the public service. There were meetings with public servants throughout this country involving thousands of people. Just on one weekend, before in fact the first parliament the first elections took place, when public servants throughout the country were raising their concerns. People's responsiveness who were in positions of negotiations, in positions, some of them, of leading organizations, made sure that within the space of 3 days, 2,700 public servants from every corner of this country were brought together into a consultation about how those sorts of dispensations should happen. But because of that, did we get everything right, do you think? I don't think that we got everything right, but equally, I would say to you that most occasions where people say, you know, if only we could do this, but we can't because of the Constitution. When you read the Constitution, and it's a very easy to read document, it really is. I mean, I carry the full version around with me and a Bill of Rights in my bag. But it's really very straightforward. There's not a lot of high-flown language. Okay? And it's worthwhile having a read. So let me give you one example. We were told that the reason that land reform is taking such a long time is because it's really tough on government, that you've got to do this user pay principle. And the worst part of our constitutional negotiations were the sunset clauses, including the sunset clause that said, people's property rights must be respected. First of all, when you read the Constitution, it doesn't say anything about user pays. Okay? Secondly, in fact, the Constitution, in that particular portion where it deals with property, actually calls on the Parliament to bring in a law of general application to enable expropriation. But if you don't do that, or the law that you bring in to expropriate land is a law that is very weak for whatever reason, then you can't blame the document that says bring in a law, but it must be a law that is of general application. Why is that important? You see, because if I'm in power and my friend, doesn't want to pay municipal rates and taxes, and I'm the person who's in power, if there's no law of general application that he or she can just take over an area, right, then how will any of us have certainty? It's the same with property rights. However poor you are, you do not want somebody, including if you're living in a communal area, you do not want a situation where you've worked all your life and all your work has got no security for your children. You can't hand it over, right? So property is as important to a poor person as it is to a wealthy person. But a law of expropriation is a law that is dealt with in the Constitution to say we come out of a very unjust past and we need to correct that past, but not because you are my friend and I am your friend, and none of us know whose friends are whose and we've got no certainty. We must do it in a way that's transparent. We must do it in a way that's accountable. We must do it in a way where corruption cannot thrive. That's the law of general application. That's what the Constitution requires. I think that we have a document that is a baseline. And like with any baseline, if you just look at it and admire it, it's not going to be too helpful. You've got to use it and build on it and build solid foundations, and I'm hoping that's what you guys are going to be able to do. So I've spoken too much, and now I want to see questions. Let's engage, and I hope that as a framing of your day, that's been a good start. I've got a hand in the back, yes. Hi, I'm good. Hi.
I would like to ask you, how often is the Constitution amended? Is it yearly, and what are the procedures amending it?
Okay, so there is no regular point of amending the Constitution, but there have been some amendments that have needed to be made. One of the obvious examples is the change of the name of a province, for example. But there have been some more substantial amendments. The amendments of the Constitution require a special majority. Some of those amendments are 66%, and some of those amendments are even higher, depending which amendment you're talking about. And the reason for that is because you don't want the foundation to be shifting and moving all the time. So it's if one does not need to amend the Constitution, then the tendency of people in the law is to say, rather amend the next layers that you base on the Constitution unless there's a real need. So for example, if we were to have a situation where we would decide that the idea of ward representation is something that should not only be, I'm just using this as an example, I don't even know if it would work, but that should not only be at local level but also provincial level. When we have the provincial elections, something like that would require a constitutional amendment. But we then have to be so clear about how we wanted that to work, we would have had to have convinced so many people that it would then eventually be able to go through. It would be one of those with a special majority. I'm going to take 1, 2. Yeah?
My question will be more on clarity in terms of Somali. I think you said they do not have laws, or what have you said on that note?
In terms of Somalia?
Yes, and you said the people, they taking the law in their hands. So I needed clarity on that.
Mm.
Yes.
So for a very long time in Somalia, there was no centralized state. Okay. What happened was that parts of Somalia were dominated by, for want of a better term, tribal or traditional leadership structures. and the whole state did not exist. So, for example, if you wanted to, or somebody wanted to transfer money, there was no central bank in Somalia because there was no central state. So that's the point that I was making. If you have one place, it must have a center which must hold, as the very well-known author Achebe has said many a time. So the center must not hold. The second thing is that, what does it mean? You asked what did I mean when I said that, people taking the law into their own hands. So if, for example, you have a situation where we've had quite a number of incidents where people have been accused, whether falsely or correctly, accused of being violent against children, sexual violence against children. There's been a frustration that people in the police have not reacted strongly and quickly enough. And we've had situations where people take the law into their own hands and beat people up and in that sense, in some cases, actually kill people. People, for example, are accused of doing things like witchcraft. Okay, same kind of issue. So that's what I meant by taking the law into your own hands. Does that clarify? You want to follow on?
Yeah. I would like to. I think in terms of what we perceive to be a mob justice, in countries like Somalia, it is something different as opposed to what used to happen in South Africa. Reason being, they are governed by certain laws. The philosophy is not, it's different as opposed to what we believe in. That is one. And on my other question, my second question would be on the matter of the land, the Khoisan. You said other people would come and claim the land that belongs to the Khoi. As Africans, only the Europeans, they came and they dissected our continent. As an African, I cannot be perceived as somebody or a strange person or a foreign person in my own land, of which there's not much distinct between me and a Khoi. And there are also certain clans in South Africa that originated from the Khoi, like the Botswana nation. There's some relation between them and the Khoi. That was the point of clarity that I wanted to put across.
So just to say to you that I would agree with you that in the African context, so one of the things that in the international context, but also even still within the African continent, the notion of indigenous people is a very narrow notion. And there's a lot of work to be done, I mean, if people are interested in working in that terrain, to get people to understand that in the African context, precisely because of decades, centuries of colonialism and decades of imperialism thereafter, that actually the migration of different communities within Africa means that when we talk about customary communities, even though those communities may not be indigenous in the context of the international notion of first people on that particular spot, in our context, customary community means that we're talking about a series of generations where the sort of practice and the rootedness in the land is as strong as it would be for anybody else. So absolutely, but that's an area that in an international discourse is really important, I think, for many of us to engage in. There is some work being done, but I'm sure that that's an area. I've got Molisi and then at the back, okay, and then I've got three more, yes. And then I'll take them all together if you don't mind, then we've got enough time.
Then I just needed to know what's your view on restorative justice, and don't you think that it compromises the victims over the offender? Just needed your view on restorative justice in for us trying to create an equal society based on justice.
Great question. I'm going to go in the order. Yes, at the back. I think it's Lucky. I'm sorry, I'm old, short-sighted. So yeah.
I'll try to shift a bit to what we were saying, but my question is, what's your take on a perception that is being created that our South African justice system doesn't serve the marginalized, most the poor? We have to have the best legal representative to serve so that the justice can serve.
Okay. Yes, 1, 2, and then 3. Yeah.
It was very interesting to hear about the constitution writing process. It sounds unusual to have such a consultative process. And I wonder if they were, at that time of writing, what were the other sort of models that you were looking at, or was it totally uncharted territories to do that sort of very broad-based consultation?
I think the point that I want to raise is basically expands on the two gentlemen that went before. Is the idea of first generation rights and second generation rights, and how the legal system essentially, well, it depends on your background, right, and where you come from in terms of which you value over the other. So with what you're saying about property rights being important, what I come to find is that in practice we actually value property rights over human rights, or over or we value the second generation rights of certain individuals or of certain groups over the second generation rights of other groups, where property rights are placed before human rights. So it's okay to say, and so I have a problem with, and I'm just wondering what you think. I have a problem with the law of general application in regards to land expropriation, because if we're saying that the law must apply to everyone because property is as important to those who have none and to those who have it, then I really don't understand how that is supposed to, how law of general application is supposed to work. Because then what you do in using a law of general application for land expropriation for people from different backgrounds is that you value the property of one over the dignity of others and their historical landlessness.
And then can I take the last question in this round, and I'll do one more round afterwards? Oh, sorry. Then there was. I thought another hand there. No, I made a mistake. Pastor.
Thank you very much. And 10 years at LFC, I googled you beforehand. It's quite an achievement. I want to ask, maybe separate from this topic, but it's great to have someone that was directly involved in CODESA in front of us. And I think I would be amiss to not ask your reflections on the CODESA process with the benefit of hindsight.
Okay, so lots of questions. I'm going to sort of piece them, answer them in a different order, but some of them are really questions of clarification. So when you have a law of general application, the idea of a law of general application doesn't mean that because it's general application, it applies the same to everybody. So for example, a law of general application would be a law that says certain communities only can be communities that can have special rights over land which would enable expropriation. Not everybody got the same rights over land to enable expropriation. The idea of general application is just that it's not my friend or your friend. Everybody knows what the rules are. That's the notion of a law of general application. So that's just to clarify that. But I'm going to come to your other questions as well, because they're absolutely fabulous. The second thing is that the notion of, some of the terminology, first generation rights, second generation rights, and third generation rights. So historically, the rights that were advanced as being first generation rights are really what we know as civil political rights. And those are the rights for everybody to be able to vote, to have a state, to have freedom of speech, freedom of expression, to be able to protest and march and so on. The second generation rights have been rights that are particularly economic social, cultural. And in many respects, those are the rights that are rights that link very strongly to what is the social and economic development framework of a country. Right? So they're rights that address, for example, the right of people to access to healthy or drinking water. And obviously all rights, civil, political, economic, cultural, social, are rights that are progressively realized. So there is no sense that you will realize a right in its fullest by tomorrow, right? But the idea is that you've got to be on the road to advancing towards an improved status all the time. And of course, when you talk about social, cultural, economic rights, the extent to which you're actually improving is not always about the right, but is about what is the financing, what is the policy, what is the governance around realizing those rights. Okay, so we'll come back to that because I'll give a couple of examples. But there is also third generation rights, and because I'm speaking to the people of the future, those are very important, and they are environmental rights. Because there is the recognition that we are seemingly bound or intent on destroying the world before the next generations can enjoy it. So I would, having given that just by way of background, it goes to the issue that I was raising in the first place. The law is not what, if the law is crafted properly. So in our country, we've got property law that says, for example, let's take our housing law, right? We've got a housing law that says it is for people to be evicted and made homeless, right, is something that if they've got no alternative place to go, you actually can't just throw people onto the streets. I mean, you might think that there are a lot of people who clearly are unaware of this law, and you would be right, or if they're aware, they don't care about the law. But the reality is that that law exists. So there are certain things in our law that quite clearly are aimed at ensuring that people who are most vulnerable receive protection. But at the same time, when we look at, well, why then is there, even without the question of illegal evictions, why then is there the kind of homelessness, right, that we see on our streets? Well, that's to do with a lot of things that are not about law, but how to use the resourcing of the state. So if, for example, we decide that we're going to resource, obviously the sort of current topic of the day, and I'm probably going to sound frivolous now, but is the fire pool. If we're going to resource the fire pool rather than, resourcing some kind of brick-making concern, well, that's spending resources here and not spending them there. So every time a decision about using resources is made, even though it's not stated, you are making a decision against using those resources for something else. Okay? Because there's an opportunity cost. What you spend here, you don't have to spend there. And that is really, when you're talking about the question of the, one group kind of rights seems to be protected more than another, it's not because of what the law of general application says, but it's how we apply that law of general application. It's what policies underwrite. And what makes that, not the law? People, communities, activists, leaders, politicians. Right, okay. Then the next thing is about restorative justice. What do we mean by restorative justice? I mean, the process of restorative justice is something that you are supposed to think about in the context of particular offenses. Okay, so let me give you an example. somebody violates the dignity of many people by inciting violence, whether intended or unintended, through the most outrageous racist remarks. You could say, I mean, there was a politician actually in the first parliament who was suggesting quite seriously that we throw prisoners down, mine shafts. Okay, you could say that. You could say that. If then, whatever. Okay, let's assume that's not what anybody in this room is going to say. The reality is, you then say, "We'll put them in prison." By the way, our prison population is way in excess. Okay. Secondly, what? Put them in prison for how long? Throw away which key? And then you put somebody in prison for something like that, and in the meantime, a person who's done the most dreadful kind of throwing acid in somebody's face, is it the same? Might well be, but how do we look at this? Maybe there's some remedial, restorative, process that doesn't have to involve that. Surely paying some money would never do any harm. Right, fine. But somebody who's really concerned about rubbish on our beaches, maybe for that person, over a period of 6 months on a weekly basis, to be shoveling rubbish from a particular township, and there's no shortage of rubbish in the township, into a truck, that could be quite restorative, right? Okay, so I think that's the issue of restorative justice. The idea is that in certain instances there is a recognition that people can actually be made through things that are put in place to change the way they view the world, or at least to really take account of what kind of consequences would follow. But the issue about using restorative justice in a way, and even using the whole idea of bail, right, in a way that does not pay regard to vulnerable people who've been at the end, is not acceptable and should not happen. Okay, it does, but that's not what is supposed to happen. Okay. The third thing is that, what do I think about whether South African justice serves the poor in the right way because of the best legal actions. So it would be very wrong of me to comment on who's the best. We've just recently had a couple of court cases that people who are representing certain sides in those court cases who cost a lot of money, I can assure you they're going to lose. Okay, so who's the best? Okay, that's the first thing. Having said that, there are organizations that the Legal Resources Centre is one. You're going to meet with many others, I see, during the course of the next day or so, who provide, honestly, the best legal representation without charging. Is that enough? No, because most of those cases are impact cases, are high court cases, constitutional court cases, and that's not where most people are. Most people are at the magistrate's court, right? So we need a legal aid system that works. Now, relative when, I don't want to just talk history, but really, when I grew up, there was no legal aid for any black person in this country. None. Not even a proper legal advice of any description. So when I look at Legal Aid South Africa, what has been done in a relatively short space of time, it's awesome. But it's most definitely not perfect. Most definitely. First of all, a number of the people who work within legal aid haven't come out of a community or activist experience. And very often, if you don't, you kind of asking questions in that sort of really narrow, bookish way. So somebody comes and says, I was thrown out of my house, and a legal aid person will say, do you have a lease? Okay, so I mean, you get my point. Okay, or I happen to be a Zimbabwean who, has lived in this country and is being forced by the wonderful Department of Home Affairs to renew my application, and they've sat with it for 7 months, and I still haven't got the paper that I'm supposed to have, and I keep on getting arrested. And when I go to legal aid, they say, have you got an appropriate visa? Okay, so we know that there are those problems, right? But I think that the issue here is that there is a real possibility to engage with legal aid, and it is important for us to do that. Not to engage finger pointing, to engage by actually doing training, to engage by working with, to engage even by helping, right? So I think that we've got to make it work. It's not an option. You've got to have legal representation, and that legal representation has got to be able to do the job. If there are problems with legal aid, then we need details. We process a lot of problems around. We work with legal aid, but we also process, as the Legal Resources Centre, a lot of problems that we receive, and we feed them back. Sometimes it involves training, sometimes it involves somebody being actually called to order, etc., etc., and sometimes things do fall through the net, like they do with anything. The idea is that's a structure, just like any of our other state-funded structures. We must make it work, because it's not an option. So that's what I would say about people who are poor. People who are poor can be represented, and we do have a legal aid that has got both obligations in terms of criminal law as well as civil law, okay? And we've got to make it work, and we've got to hold it to account. The last thing, I think that I've answered everything else. The models in the constitution-making process in CODESA. CODESA is quite a long topic, and I think maybe that's something to engage around, about what do we mean by negotiations, and what would constitute a sunset clause and a not sunset clause, and how do I feel about some of the things that were decided. I can tell you that for me, some of the issues that were decided in terms of the dispensation of CODESA, for example, I personally always wanted a situation where we had a national and a local government kind of division. The idea of provinces was something that I felt was not, I'm talking about myself personally, and I know the others who I was with, was something that was, to a certain extent, a compromise, for want of a better word. When I look now, I think that there are huge problems with the way the different governmental structures work. But I must admit that I might not be so keen on provinces even now, but it's quite clear to me that to move from local to national, the gap is very wide. And so one might have to think about regional kinds of formations. And a lot of that thinking wasn't there. So I'm using that just as one example. I could give you, I'm happy to sort of talk through some of those at a later time. But what I would say is that in the lawmaking process, in the first parliament, there were possibly even, for me, there were really a lot of compromises that I thought got made along the way. I think that, and those are things that are not about sunset clauses. Those are things about a parliament that's, a robust elected parliament. So it's not that you make compromises once. You make compromises as part of a process of pulling together a society, and maybe that's something to look at. And sorry for not having the time to go into some of the details. Models in the constitution-making process, we used a phenomenal range of models. And we used different models for different things. So for example, when we were talking about the public service, we looked at the American public service structure, how it is processed. we looked at the British, we looked at the Indian, we looked, I mean, this is in a lot of detail. There were people who came from there, people who went there to study, and we looked at the French. And the idea there was to actually get models that had influenced the African continent also as a whole. Because a lot of the French on the one hand, the Portuguese, which is much more much more varying towards the French, but has European context to it on the one hand, and then the English stroke US kind of modeling on the other. So there was a lot. When we looked, for example, at things to do with the structures of government, I mean, there were a lot. I was not involved in those particular studies. There was a lot of discussion about the federal structure of Germany. There was a lot of examination of some of the structures, again, of African countries like Nigeria, where, you know, there are different sorts of structures in terms of their decision-making processes. Of Latin America, again, of the United States. There was some delegation that went to Australia. So it depended which section of the Constitution. And sections of the Constitution, not just chapters, but in some cases specific clauses, involved a series of academics coming together, series of activists coming together and having that process. And there is a book around the constitution-making process that I don't have the title now, but I'm happy to send it. Yeah. So. Last round, yes.
Has the LRC been involved with the National Planning Committee?
Has it been involved with the
National Planning Committee?
Okay, so with the National Planning Committee, we've been involved to the following extent, not directly in terms of the drafting, but we've had engagements on specific themes. So, for example, around water, around issues to do with trade and industry, because we were asked to do some thinking about the international trade law system that we were governed under at that stage, the bilateral investment treaties. Now, as you know, there's a new law that is in Parliament. So we did have some engagements around quite specific things. Most of the engagement that we've had since then has really been by way of trying to track and reference what the thinking is behind some of the legislation and so on that's coming in. So it's much more dealing with individuals. Yeah.
I just have a general comment. Like, I think in general, I'm like one of the biggest fans of our Constitution. I feel like it's one of the flagships of humanity in terms of the kind of rights it protects, or it is meant to protect. And I think like my comment is mostly based on the fact that when it comes to certain aspects of our Constitution, certain individuals have vested interests. When it comes to other aspects, then we tend to be very avoidant or ignorant towards what the laws actually state. And that particular example would be how we deal with LGBTI rights, for example, where you have people are very much passionate, very robust in defending racial antagonism and racial prejudice. When it comes to other rights, then we sort of become very avoidant. So I'm just like interested in trying to find out how we can actually get to a point where each and every single right, which is enshrined in our Constitution, is given the same kind of prestige. Because it seems like others' rights are prioritized over others, which of course leads to a very much, it is detrimental to social cohesion overall.
So, I mean, I think that, first of all, the general point that you make is completely correct in that there are certain things that almost become, that sweep the consciousness of the society at given moments to the exclusion or overlooking others. And probably it's most stark when you look at the way in which people who are in South Africa from neighboring African countries how those people are treated in terms of just dignity, in terms of embracing the skills that they have. And that wouldn't even begin to address whether or not you should have an immigration policy and what should it look like. But it's just being able to treat people in a way that is equal. So, when people talk very often, even now, although it has lessened somewhat, but not enough, when people talk about foreigners, and they're like, oh, these foreigners, do you think that they mean people who come via OR Tambo from New York? No. I mean, we're talking about people who have to escape the most awful situations in places like Rwanda and so on, and who come here. So there is that difference. Secondly, the issue about the some of the rights in our Constitution is that we kind of have really led the world. It's only fairly recently that places like the United States apparently have discovered LGBTI issues. Okay, so and that's great. That's great that they're learning. I think that part of our deficit is to have the conversations as robustly and as needed as they are. And it's kind of only when things get to a crisis point that people then actually jump in. So I would say that we're not for example, we might be a country that for now embraces levels of diversity when it comes to religion. But it's not something to take for granted. And by religion I mean even those people who are atheist and agnostic. But the reality is that it's not something we can take for granted ever. So we have to cherish, we have to preserve and question and raise. And a right won't be understood outside the context of understanding more than just a right. If people don't understand, for example, with the LGBT community, I mean, when you have a man and a woman who are in a relationship together, somehow the total sum of that relationship is not translated into sex. So why do we do something quite so inane when we're talking about people of same-sex orientation, right? So the reality is there isn't that conversation that's going about what are we talking about in terms of different communities. It's when we talk about people who live in the deep rural areas of KwaZulu-Natal. Do we really have a sense of what makes the customary practice of that community? It's not something that some colonialist wrote in a book. It's what's the living experience of people now. And until we understand living experience and embrace it, accept it, learn from it, we will take for granted what is so precious in this document. And that's really up to us as people who work within the community, you as people who are going out to embark on a whole range of opportunities. What's your kind of burden of responsibility? Last one.
Okay, I just hope I can phrase this quick as possible because I guess what time we usually have to go. But
I'm just worried about you guys surviving this.
My question is very simple. What is the LRC doing to kind of maybe amend the education system in South Africa to bring the Constitution to young people?
Okay, so it will have to be the last question because I might talk for a while. Okay, so the LRC probably has both used the law and used other means to engage around the education space for some years. So for starters, when it comes to looking at quality education, in our view, quality education is determined by a range of things, but including infrastructure. So one of the biggest cases that we dealt with around education a few years ago is known under this term, the mud schools. So what happened was we were approached by a group of schools who had been literally operating in mud huts, and one of them, in fact, the mud hut had been washed away a few times by heavy rains in the Eastern Cape. And we then represented that group of schools as individual schools, and we did, in our initial stages, which is what we usually do at the LRC, we went to try and discuss, to try and negotiate, to try and find non-court solutions, because court is long, time-consuming, expensive, and we failed. And so we submitted court papers, and the day before it got to court, we got a phone call from the department who now wanted to discuss. We said, no, it's fine, we're very willing to discuss, but just know that now that we're this far, anything we discuss will be made in order of court. So what then happened was we got a court order that was not only for the building of the 7 schools that we represented, but was to require the state to set aside money for 400 mud schools. So the first thing I think that arises out of that is the issue about recognizing the fact that there are, just like we've still got people who have to use the bucket system for sanitation, we still have schools that are mud schools, but progress has been made. There are roughly 185 very well-established, well-constructed schools that have been built in very remote rural areas, particularly in the Eastern Cape, where kids are seeing structures that they've never seen in a school situation. So there is some progress, and it's kick-started a process of school building that the department has adopted as its own, and we don't mind that. They can adopt as long as the work gets done. So that's the one case. We then represented one of the civil society organizations, Equal Education, in its case that was requiring of the minister to set norms and standards, particularly for infrastructure. So it's called the Norms and Standards case. In the Education Act, there's a possibility to set norms and standards, but no norms and standards were set. And our courts rightly don't want to set the norms and standards. They don't want to say, you must have this and you must have that, right? But the law said the actual people who are elected will do that setting of the standards, but they hadn't done it yet. So it was very difficult, it remained very difficult to hold people to account. So that's the second thing. We worked more on workbooks than textbooks in terms of delivery, but of course the two are fairly interrelated now. There was a big workbooks case in the Eastern Cape, obliging the state to deliver workbooks to the schools. And we now are involved in a case that deals with learner-teacher support materials, the chalk, those kinds of facilities, and of course, in relation to the actual infrastructure, issues to do with sanitation. The other big issue around learning, of course, is teachers. And in the Eastern Cape, we were again approached by a group of teachers who had been appointed by different schools into positions that existed officially in terms of the ratios of pupil to teacher, but they were appointed as temporary teachers. And the reason that they were appointed as temporary teachers was because there are a number of teachers in Eastern Cape who are in positions, but for various reasons of ill health, of inappropriate qualification, of disciplinary procedure, are officially not teaching, but they occupy a space. So the opportunity to put the people who are teaching on the permanent payroll was then, it was crowded out, basically. And so you had temporary teachers who were teaching in positions that they were supposed to be teaching, but some of them were not being paid on time, because if you're a temporary teacher, you kind of get paid outside of a regular payroll. So we had one teacher come to us and she hadn't been paid for 4 months, and her own children were unable to have shoes because she couldn't afford them, right? So we then represented those teachers, and we were able to represent them in a class action which was designed to not have an order. So this is where you use the law. It's what order do you create? That's very important when you use the law. So when you say, here's the problem to the court, here's the law which tells you it's a problem, and therefore please to solve the problem, you also want to give a plea to the court of how to solve the problem. So when we identified this problem, because in some of the other cases I've mentioned, we had a situation where even though we got the court order, it wasn't implemented, right? So now we want, because, build mud schools. It takes a long time, and you've got to monitor. We even employ somebody to do the monitoring. But the point is that what we wanted was an order that actually was much more measurable, right? So to make it measurable, we identified those schools who had been able to pay their teachers. And we went to court to say, there are many teachers, these are a sample, but with these teachers, what we need you to do is we can quantify exactly how much they've been paid. Here's the proof. We want you to give us an order that this refund must be made to the school governing bodies by such and such a date. Okay? And these people must then become permanent employees by such and such a date. Now, by doing that, firstly, the schools got their money that they can use now to make sports fields and to, improve things. But it then gave us the basis for a bigger action on behalf of all teachers who were not being paid and temporary. At the moment, we're also working around violence in schools, but that's not so much using the courts. It's trying to get a lot of stakeholder engagement with school governing bodies and with various organizations, not just the Legal Resources Center, drug counseling, trauma counseling, etc., also emergency response, to try and deal with it. So we're very vested in it, but it's something you can hear. You hit one problem, you tackle the next, Who tackles the whole? Not the lawyers. Do not think lawyers bring you the solution. The solution is brought by community. The law is just one tool to help. Thank you all very, very much.